as a student of constitutional law. I do not have any political ideology. I don't want to profess any political ideology. But I want all of us must get into what is known as the constitutional issues and concerns with regard to what is known as Indian Citizenship Amendment Act. What are the constitutional issues? Now, before I deal with the constitutional issues, I am not dealing with the provisions of Indian Citizenship Act. Constitutional issues. Let me preface. You remember that as a student of constitutional law, student of political science, you look at the Constitution in what way? It is an embodiment of executive, legislative, and judicial power. Which means what is the structure of the executive? What is the structure of the judiciary? What is the structure of the legislature? What is its interrelationship? What are the limits of executive, etc., etc.? That is how you look into, as a student of, you will find political science in the beginning. But if you look into, for example, I think I was told, I may be wrong, that the Constituent Assembly took about 2 years, 18 months, and 11 weeks to give us a massive, mammoth, monumental document, which we call today, according to Article 393, Constitution of India. It was given on 29th November 1949, and that 29th November is celebrated today. We commemorate that particular day as what is known as Constitutional Day from 2015 onwards. Before 2015, it was celebrated as Law Day. Now, if you look into this Constitution, I will preface my lecture deliberately. It is a macro policy. It contains the macro policy. What should be your agricultural policy? What should be your monetary policy? What should be your industrial policy? What should be your educational policy? Now, all these policies, you must correlate to the provisions of the Constitution. Although constitutional provision may undergo transformation. For example, when we started in 1950 or 1954, Congress party at that particular time adopted what is known as a socialistic pattern of society. Our resolution. The society, it was a socialist state. Today, we cannot talk about the socialist state. We have to speak about liberalization, privatization, globalization. So the Constitution must be interpreted in this context, whether you like it or not. So therefore, what I am trying to tell you is, it is an embodiment of macro policy in its comprehensive sense. And what we want to achieve, I may know, whatever may be our ideology, we should try to achieve it through the Constitution. And suppose the Constitution is not able to achieve those policies, those objectives, we have to get out of the Constitution. Revolution might take place. If the Constitution, that is why preamble gives you a constitutional paradise. If that paradise has not been achieved, but we want to achieve justice, liberty, fraternity, equality, unity, integrity, everything. We want to achieve it. You will find. So that is why it is a public policy. The second point I wanted to tell you is, the Constitution of India embodies what is known as rule of law. It is what you call a repository of rule of law. Because the society is, you will find, multifaceted. Polity is multifaceted. And therefore, what happens is the Constituent Assembly took into account what is known as certain prohibited markers. What do you mean by the word prohibited marker? The Constituent Assembly looked into the Indian society. What is the most important markers where discrimination is practiced? For example, religion, race, caste, sex, place of birth, descent. So these are not that there are no other things. For example, age. Today, age may be a factor. You will find you do not look after the children. Prohibited mark. Senior citizens like me, for example. These are prohibited. But what I wanted to say was, they took into account some of the prohibited marks and they said, you shall not exercise your power. You will find through these prohibited markers. That is why there is what is known as rule of law. Rule of law is required. Now you cannot say a teacher must have, you will find so much of height, he must have so much of weight, etc. Because teacher does not require that particular thing. What teacher requires is brain. And of course behavior also is important. But when you enter into army, that may be a factor to be reckoned. So what is relevant for a particular profession may not be, need not be relevant for another profession. For example, suppose today you are appearing for an examination after my lecture. No, I will not ask you who is ultimately vegetarian, who is non-vegetarian. That food is not relevant for your 2 hours exam or 1 day. The examination is continuous. Say 20 hours you are having an exam, then you may have to serve food in between. But you go for a picnic, for example, vegetarian, non-vegetarian. So that classification is required. So that is why it is a repository of the rule of law. So now we come to what is known as Indian Citizenship Act, Amendment Act. What is it? 2019? Not 20, it was at the end of, beautiful. Now, remember, under the provisions of the constitutions, there is Indian citizenship at the time of the amendment of the constitution. I think nobody here is citizen according to constitutional provision. In this class today, only I am the citizen. Article 5. Domicile within the territory of India, born within the territory of India. My father and mother and my great parents were within India, they were British. I am the only man who is a citizen. All of you, subject to correction, you are citizens under Indian Citizenship Act of 1955. Because we were citizens at the time of the commencement of the Constitution. It is given in Article 5 to Article 10. And Article 11, read with entry 17, Union List. Entry 17 Union List, if I am not mistaken, is citizenship, naturalization, aliens, about which Parliament alone has got the competence to make the law. It is an exclusive power within the Parliament, not with reference to the state legislature. So, when we are talking about this particular amendment, Indian Citizenship Act, Indian Citizenship Act was made 1955. 3 amendments have taken place. 2003, 2005, which are not material amendments. Those Indian citizens who have become citizens of outside, what is known as diaspora. What do you call it? they must be given certain benefits, etc., etc. That is why Indian Citizenship Act was amended in 2003 and 2005. Now the present amendment is, you will find 2000, you will find 19. That, and if I have not read the provisions, I will remember, but if I understand the provisions generally is that if you are Hindu, or for that matter Christian, Jain, Buddhist, etc., from you will find Pakistan, Afghanistan and Bangladesh, then you will find you, and if you are residing within the territory of India before 2020 or 20 whatever, for a particular period, you are entitled for citizenship. So that is, you will find the provisions there. Now this act, the question that we will have to look into is, before I deal with the impact of this particular act from two criteria you can look into. First criteria is fundamental rights. I am just thinking like that. I have not gone through the petitions filed by so many people, including state of Kerala or whichever other state they have gone into. Two areas where we can ultimately challenge is with reference to fundamental rights and with reference to what do you call federal principles, relevant provision of federal principles. That is why you will find. Now, before we enter into the Act constitutional issue, one point you always must remember. What is that? Supreme Court in many of the judgments, whenever we are exercising power, not merely the central government, not merely the state government, not merely the government executive, all of us, we are power holders as well as power addresses. As a teacher, I am a power holder. As a student, you are a power address. When I file income tax return before the income tax officer is the power holder. I am the power address. And whenever we do, I told you it's a macro policy, it embodies rule of law. So what is required is restraint. Restraint is required. It is very easy to be aggressive. Anybody could become aggressive. I can put one stone there. Nobody will bother. But we have to be very restrained because we are talking about what is known as government, which is supposed to be governed by the rule of law. Second, sovereignty. You must be sober. I must not be moved by any of that you will find. As somebody said, you can resist anything but temptation. So therefore, sobriety is required. And we require moderation. Moderation is required. They said, Supreme said on many occasions. So I am feeling of restraint, what you call self-restraint. Feeling of, you will find sobriety and feeling of moderation. That is why we want the Constitution. Why we want the law. Why we want criminal law. Why we want civil law. Earlier we were fighting together. And one who is mighty, he is the winner. Today mighty cannot be the winner. So therefore, law is required to restrain. So that is why you will find this particular statement. Now, another important thing before I deal with fundamental rights applicable, what would be the arguments? I have not read the thing. As a student of constitutional law, I am contemplating this may be the argument of the government. This may be the argument of the petition. So, one important point is whenever a word is used, law, it's very important because we are sometimes we put our cart before we will find cart before the horse. We should not do. Wherever the word law is used, Supreme Court has said it it must be a valid law, not mere law. And who has to decide whether it is a valid law or not? Not we, the people of India. Not even the representatives of the people cannot decide whether the law is valid or not. It should be decided only by the Supreme Court now, because the case is pending before the Supreme Court, whether you like it or not. My opinion may be ultra-virus, it is war, a big issue. But the Supreme Court may not look into that, my argument. Or the Supreme Court may accept my contentions comprehensively. It can happen. But I can always say unconstitutional. Okay. Prima facie it may appear to be the unconstitutional. But court may go into the provisions of the law. Court will. So therefore, why I am trying to tell you, wherever the word law is used, for example, no person shall be deprived of life or personal liberty except according to the procedure established by law. Supreme Court said law must be a valid law. Then only you can deprive. Then Article 19.2 to 19.6 says reasonable restriction can be imposed by law. Law must be a valid law. Article 265, no tax shall be levied or collected, save by authority of law. Not mere law. Law must be a valid law. Article 308, introduced or inserted by 44th Constitution, no person shall be deprived of private property except by authority of law. Law must be a valid law. So, why the Supreme Court said it should be a valid law? Because there is a famous case which you must not forget. Any student of taxation, he must remember that particular case. You will find about this valid law, and some of the courts in Asia adopted this principle. For example, Malaysian Constitution. This has been valid. Law must be a valid law. So what is the case? The case is KTM Nair versus State of Kerala, AAR 1961 Supreme Court. I will give you the material facts of the case. You remember, the KTM Nair means Unnat Tattunni Nubil Nair, KTM Nair. There was a law passed by the Trivandrum Cochin Assembly, what is known as Land Tax Act of 1955. In 1956, 1st November 1956, what happened was Malabar, which was under the Madras state, became part of the Kerala state. Trivandrum Cochin merged with Malabar. So this act, Trivandrum Cochin Land Tax Act, what it did was the uniform imposition of tax. Rupees 2 per acre. If the land has got, now the land may be a rocky land, fertile land may be where you are growing, you will find cash crops, irrespective of the nature of the land. It is not capable of being irrigated, or it is maybe capable of being irrigated, you will find. So, irrespective of the utility of the land, irrespective of the quality of the land, the uniform rate of tax. So, Mr. KTM Nair, he was alleged to have 25,000 acres of the forest land, on which he was required to pay 50,000. And the cases you will find in 1959, 1960, 50,000 means it is as good as 1 crore, 2 crore, that value. So he challenged the constitutional validity of that law. It is ultra minus Article 14, right to equality. It is a violating of Article 19, 1F, right to hold, acquire, dispose property as it originally stood before 44th Constitutional Amendment. It's ultra vires Article 31 of the Constitution, right to property as it originally stood. It was argued, it wasn't like that. Now, the contention of Mr. Nayan was accepted. I am not looking into that. But one of the arguments advanced on behalf of state of Kerala was, this is what is important. They said, look here, Article 265 says, imposition, levy and imposition of a tax must only be done by law. We have done it. We have satisfied Article 265. We have imposed a tax. And under demand to question that once Article 265 is satisfied, none of the provisions of the Indian Constitution are applicable, including whether it violates fundamental rights. That was the preliminary objection raised on behalf. That means what 265 requires is a law. We have passed that law. And once the law is done, it is part 12, subject to correction, part 12 of the Indian Constitution. Nothing is to be looked into. This is on the ground, what is known as theory of exclusivity of fundamental right. In A.J. Gopalan versus State of Madras, AIR 1950, page 27, the Supreme Court developed a theory of exclusivity. If a person is detained in pursuance of preventive detention, 21 and 22 are only applicable, but 19 is not applicable. This is theory of exclusivity of fundamental right, which has been given a go by Manika in this case, which now say composite code theory. So applying that principle, it was argued on behalf of State of Kerala. Look here, we have made the law, and that's the end of it. You have to pay tax. And the constitutional validity of such tax law cannot be challenged. It is not a law for purposes of Article 13(3) of the Constitution. But argument of M.K. Nambiar, far you will find P.K. Venugopal, Attorney General at present, who are you will find on behalf of it was said it should be a valid law. Law must be valid. Mere law is not sufficient. You must be able to prove such law. So how can you say a particular law is a valid law? Supreme Court said 3 criteria. First, that law should not violate fundamental rights. So violation of the fundamental right is one looked into. Second is the legislative competence. Whether Parliament has got the power to make the law. Parliament has legislative competence to make the law under union list, under concurrent list, under residuary list, Article 248. It can make a law under specified circumstances in respect of a matter enumerated in the state 249, 250, 252, 250. Legislative competence you have to be. Otherwise, the law will be struck down as beyond the power of the Parliament. The law will be struck down as beyond the power of the legislature. That is another ground. Third ground is mandatory provisions of the Constitution, other than fundamental right. So you have to look into that. That is why you will like what is required. It's a valid law. So this will come when we deal with 2 articles. This will be very relevant. You will find it should be a valid law. If it is not a valid law, certain consequences take place. So that is one aspect. This is therefore, whenever any word is used, whether it is valid law, first you must decide the validity of the law, constitutional validity of the law. My shouting that the law is invalid will not make that law invalid. So, and there is another point also. The second point is, under the pre-constitutional regime, we have got what is known as test of constitutionality. How to decide this test of constitutionality? Whether it is violative of fundamental right, whether it is violative of the legislative competence, whether it is violative of any other mandatory provision. Test of constitutionality. I will give you one case which is very important. You will find. The case is State of Bombay versus Bombay Educational Society. Here you are, 1954 Supreme Court. Very important case. First case, test of constitutionality. Because all of us, I remember my professor S.P. Sathe, when he was teaching constitutional law and administrative law in Bombay University, he used to say, every student of constitutional law is a student of the judicial republic. So therefore, what is this test of constitutionality? We have to know it. Simply talking around, we will find, we can talk many things. Nothing, but we have to know what it is. Now, in question that fell for consideration or for determination before the Supreme Court in this particular case was the Directorate of Education of the Bombay State issued a circular January 1954. What was the circular? The circular pointed out, if you want any student to be admitted into English medium schools, his or her mother tongue must be admitted. Otherwise, you will not be permitted. That was you will find. So, Mr. and Mrs. Shah wanted person to be admitted into famous Bombay Educational Society. Bombay Educational Society has got some wonderful schools in Greater Bombay. Barn schools, etc., etc. So they went, Mr. and Mrs. Shah. Then the principal said, I would love to admit more of the student barrier, but I cannot admit because your mother tongue is Gujarati. Mr. and Mrs. Pinto wanted their son to be admitted. He said, I would love to, but the circular is against my admission because your mother tongue is Konkan, Pinto from Goa. Or manual, as a case is. So therefore, the rector of this institution, principal of the institution, along with the rector and the parent, they filed a writ petition before the Bombay High Court. Their contention was that this particular circular issued by the government of Bombay, Directorate of Education, violates Article 13 and 2 of the Constitution. According to Article 29 and 2, no citizen of India shall be denied admission in an education institution owned by the state or receiving the grant from the state on the ground of religion, race, sex, sexual origin, caste, and language. So you are denying me admission because my mother tongue is, Gujarati. My mother tongue is Konkan, and therefore it is violent. Now the argument of the Advocate General was, to see, look into the object of the state action. What is the object of the state action? Now you remember that in English medium schools, people will be, even person who says, we will find Marathi, this one, all the politicians, the children will be in the English medium schools. Marathi, but children will be in the English medium schools. But you are not getting enough students in the municipal corporation schools. And there are Hindi medium schools, Gujarati medium schools, where you don't get enough because everybody is restricted to that. So the object of the state action, because I named the object of the state action is, you will find very laudable, progressive development of all the national languages mentioned in page So there are national languages in 8th school. We want to progressively develop that. And if development is required, we must come to the conclusion only whose mother tongue is English should be. Then we will get into Hindi medium, Gujarati medium, Marathi medium schools. So that is the object. So since the object of the action, that will determine the constitutionality. That was the argument you will find. But it was contended on behalf of the Bombay Educational Society. Don't look into the object of the state action. Look into the impact and effect of the state action. Whether what is the impact of the state action? When you exclude the students from, you will find Marathi medium, etc. Only English medium is permitted. Exclusion to other categories. My prohibited mark is a language. Article 29.2. My right as a student is by language. So that is you will find. The Supreme Court upheld the contention and said, whatever may be the object of the state action, it may be laudable. The object of the state action may be, in order to find out what is the object of the state action, you must look into the form of state action. Why the state is doing something? Is it to protect the security of the country? Is it ultimately to maintain the tranquility they are doing it? That is one object. Now, in this particular, so therefore, the contention that in this case, it is the impact and the effect of the state action that is relevant. And this was reiterated, repeated by the Supreme Court in bank nationalization case, CAA 1970 Supreme Court, and Benefit Government Company versus Union of India, CAA 19. But only under the impression the Supreme Court always will look into only effect and impact. It depends upon the issue. There will be 4 issues before the Supreme Court. In this particular issue, object of the state action is important. Second issue, then under the third partly. So therefore, but due to the development of the what is known as activists, due to the importance to be given ultimately to the human rights, Supreme Court is slowly predominant. What is known as judicial, what do you call that? Judicial spectrum. You will find judicial spectrum. It is running from one end to another end. So that will decide, you will find. For example, emergency is the proclamation of emergency, object of the state action. Detention will not be looked into. So that is why, therefore, this is how you have to look into that it is a very difficult position because unlike the legislature which gives you a policy in the form of law, unless the executive which implements the policy and says this is what we are required to implement it, the duty of the judiciary is sometimes stupendous. But what they say, what is the effect? What is the impact on the people of this country? What will happen to the security of the country? What will happen to the rights of the people? All this will have to be weighed. What's in count. And they are also what was decided earlier by the earlier age. So all these are things you will find out relevant, you will find. Now we come to what is known as, let us deal with fundamental rights. Basically, let us deal with the fundamental rights. So whenever an individual goes to the court, and as long as the Citizenship Amendment Act is, first, it is a discriminator. Article 14, they have raised that issue. All of them, pro CAA, they have raised that it excludes Muslims. Since it excludes Muslims, it is a violating of Article 14 of the Constitution. Now, I am not going into that part. Now, what will be the answer to be given by the state? That's the most important. The state can give any answer. To my mind, the state might try to, you will find, answer the historical consideration. Read Article 290A. Anybody can read Article 290A. Yeah. And read it very carefully because you are a student of constitutional law. 290A. Don't read like the advertisement says. Read slowly, steadily. This is not an advertisement, so you can slow down. Article 290A. Read it. Yeah. No. 298, just for the benefit of the student.
Article 298. In the case of a charge on the Consolidated Fund of India, the court or commission.
Am I making a mistake? No, 298. Where did you get this? 290 you are reading. A adjustment means 290 A means second half. I was wondering whether I am misleading you. Yeah, read it.
298. Annual payment to certain derivation funds. A sum of 46 lakhs and 50,000 rupees shall be charged on and paid out of the consolidated fund of the state of Kerala every year to the Travancore Derivation Fund, and a sum of 13 lakhs and 50,000 rupees shall be charged on and paid out of the consolidated fund of the state of Tamil Nadu every year to the Derivation Fund established in the state for the maintenance of Hindu temples and shrines in the territories transferred to the state on the.
What is your feedback? Do you like this provision? Why? I know, that's why she is asking that what she is trying to say, if I am not mistaken, why it is only for Hindu temples. Another question you are asking. So how do you do? Why that provision is there? Because historically speaking, in Travancore temples, they were said to be the temples of the ruler. It is made owned by the owner of this one. Therefore, when the State Reorganization Act came, certain talukas of Trivandrum district, it became part of Kanyakumari. Kanyakumari was merged with the state of Tamil Nadu, and rest it was, you will find, with the Kerala. And therefore, historically speaking, taking into account historically, they were given. My old professor S.P. Sati, he used to say, Article 290A is against the concept of secularism. But nobody has still challenged it. And if they are challenging it, historical consideration. Because I will give you, there was one section in the Civil Procedure Code, I think section 87A. Section 87A is subject to correction. Section 87A categorically pointed out that you cannot serve processes, civil processes, on Maharajas. So the question was why? Why Maharaja? So Maharajas entered into instrument of taxation with government of India, dominion of India. They surrendered ultimately land, everything. And therefore, some special provisions were made, which is of historical nature. I think there is a case, just I wanted to give you that particular, not in Narottam Kishore. Narottam Kishore versus Union of India. I don't remember the year of that year. But they said this is valid, historical consideration. Then there is another case, what is known as State of MP versus Bhopal Sugar Limited. In the Madhya Pradesh state, in the Bhopal region, agricultural income was different. Whereas in other areas of Madhya Pradesh, historically. So historical reason, maybe you will find ultimately be looked into ultimately to support. But my point is that we do not know what will happen, how the arguments will advance. But to my mind, what is more important is another article which has got federal implications, which has not been looked into by the Supreme Court up to now. And the case article is Article 256, Article 257. Very important. And the scope of these articles will be determined in order to find out whether Indian Citizenship Amendment Act of 2019 is constitutionally valid. Because one chief minister from North India said it is not applicable. This law is not applicable. You may say, I will not implement it. Okay. I will not implement. If that implementation is required to be done, you may. The point is, suppose that, the point that is to be understood is, in a federal system of constitutional system, when the parliament is making a law, the law will be applicable to the entire territory of India. Of course, earlier, except state of Jammu and Kashmir. After 370, it is different. It has to be applied. You cannot, it will not be applicable. Not from tomorrow can the parliament stand like central executive say this law passed by the Karnataka will not operate here and this and that. No. It has to operate within the territory of Karnataka. That is the legislative classification. Article 245, 246, read with 7 schedule to the Constitution. So therefore, when you are holding an office under the Constitution, I can say as a citizen, I will not implement it, it is not applicable to me, it is not applicable to Kerala, it is not applicable to India, that is Bharat. I can talk as a citizen. But an office, constitutional office, he cannot say it is not. Chief Minister said it is not applicable. Speaker said it is applicable. You cannot say that. So what are the provisions? That's the most important thing. Read Article 256, the scope of which will be decided by the Supreme Court when the constitutionality of, you will find, this law is determined. Read slowly Article 256. Yeah.
Administrative relationship. Chapter 2.
Everybody knows.
Chapter 2, Administrative Relationship. Article 256.
Slowly.
Obligations of states and the union. Obligation of states and the union. The executive power of every state shall be so exercised as to ensure compliance with the law made by Parliament.
Stop it. So whenever state, what is state? The unit of Indian Federation. When they are exercising their executive power, they must exercise their executive power in such a way it ensures compliance with the parliamentary law. There is no doubt Indian Citizenship Act is passed by the Parliament. Parliament has got the legislative competence, is in the union. So when they are trying to implement it, rightly, wrongly, etc., then the state should not come in the way. The exercise of the executive power of the state must be so as to ensure it is ultimately parliamentary law. Compliance with the parliamentary law. You cannot say I will not implement it. This now is not applicable. You cannot say. When you can say, if it is an invalid law. If it is an invalid law, who will determine it? Supreme Court has to decide it. If the Supreme Court decides it, it's ultra-virus Article 14 on the ground of religion. The state need not implement that particular law. But so long as that has not been done, the law is valid, presumption of constitutionality. And the Supreme Court has not given a stay. Kindly remember, stay was asked, stay was refused. So therefore, the point is that every state, which is the unit of the Indian Federation, when they exercise the executive power, what is executive power? Executive power is implementation of the law. Executive power you will find is enforcement of the law. Executive power is, if they are required to do it, you will find they must do it in such a way they don't go against parliamentary law. Suppose they go against the parliamentary law, what happens? They go against it, as most of them have said, that we will not do it, we will not implement it, we are not for it, we are not only for that, NRA, whatever. Now what happens? According to Article 256 of the Constitution, if the state fails come in the way of the implementation of the parliamentary law, and direction can be given ultimately by the union. They can give a direction to ensure that purpose, means to see that the law is implemented, not for any other purpose. Suppose they don't implement the law, they don't implement the directive. What happens is Article 365 will be invoked. Article 365 will be invoked. What is Article 365? Read Article 365. 3365. The sanction for not implementing the directive by the you will find the state mentioned in 365.
Effective failure to comply with or to give effect to direction given by the union. Where any state has failed to comply with or to give effect to any directions given in the exercise of the executive power of the union under any of the provision of this constitution, it shall be lawful for the president to hold that the situation has arisen in which the government of the state cannot be carried on in accordance with the provision of the constitution.
That means to say, if 365, if 256 is not followed, direction is given by the union, the consequences are contemplated under 365. And what 365 says is, you can impose president rule under Article 356. It shall be lawful for to assume a situation in which government of the state cannot be carried on, which means 356 says, if there is a failure at the breakup of the constitutional machinery, you can impose, you will find by the president. Of course, there are difficulties in the imposition of the president. What are the difficulties? First, you must have majority in both houses of parliament. You may not have. Sometimes you may not get, you will find regional parties who are allies of NDA may not support if it is an imposition of the president. Number one. Number two, the imposition of the president rule under Article 356 earlier was dissolution of the House. You can dissolve the House immediately. But now the Supreme Court says, don't dissolve the House immediately. You suspend that ministry, keep that executive in animated suspension or suspended animation, and get the resolution passed. Because the resolution is a prerequisite. You may not have that much of majority, because the majority is valid. For example, in NDA's case, Nitish Kumar will say, no, I am not for the imposition of president rule. Paswan may say, no, I am not for the, you will find. Then Akali may say, you are not for the imposition of president rule. Then you may not get the majority. And earlier view of the Supreme Court was, with regard to imposition of the president rule, automatic consequences of the imposition of president rule law is what is known as dissolution of the House. And once the House is dissolved, election, re-election is ordered. But in Bombay versus Union of India, Supreme Court has categorically pointed out, if they come to the conclusion that the imposition of the president rule is violating of the provisions of the Constitution, then we will resurrect that particular legislative assembly without general election. So, according to me, political support, what I want to say, from the allies and the judicial review, imposition of the president will need to be difficult. I am not saying it is impossible. It may be possible also. So nowadays, imposition of the president rule has become in the rarest of the rare, what Dr. Ambedkar says. Because not only the judiciary come in the way, the electorate will punish in Bihar when the imposition of the president rule was there, when Bhuta Singh was the governor, then the Congress party was defeated after the re-election ultimately was set. So therefore, in order to invoke Article 256, one thing is required. What is that? The existence of a parliamentary. Of course, other law also it is there. Existence of parliamentary law, the exercise of the executive power of the state, not to comply with provisions of the parliamentary law. Then 365 will come. 365 is equivalent to Article 353, subject to the evidence. So this is one article which is, because federation is supreme, it is known as supremacy, federal supremacy, whether you like it or not. Because on the same set of people, on the same territory, two laws must operate. And the law of the parliament will have to operate everywhere, you will find. And the territory of India, kindly know, it is not a geographical territory. Even outside the geographical territory, you have got territorial waters, you have got exclusive zone, you have got maritime grid. Read Article 297. What is the territory? Not the geographical territory. 297 of the code. Because,
Things of value within territorial water or continental shelf and resources of the exclusive economic zone to west in the Union.
yeah.
All lands, minerals and other things of value underlying the ocean within the territorial water or the continental shelf or the exclusive economic zone of the India shall vest in the Union and be held for the purpose of the Union.
So therefore, it is not merely geographic. Territory of India does not mean that territorial waters are there. Oil exclusive economic zone, maritime belt, etc., etc. It goes subject to the provisions of the rules of international law. So this is, you will find the second federal supremacy clause is under Article 257. Can you read Article 257?
Article 257 A. Assistant. 257. Control of the Union over state in certain cases. The executive power of every state shall be so exercised as not to impede or prejudice the exercise.
So therefore, when the state is exercising the executive power, it must exercise the executive power in such a way that they should not impede or prejudice. It should not prohibit the exercise of the union power. That means union executive power is greater than state executive power. What is the difference between 256 and 257? Anybody? Is there a difference between 257 prima facie? Anybody can throw light about it? Under Article 256, it is a conflict between exercise of the executive power of the state, unit of the Indian Federation, and the law, parliamentary law, or any other law applicable to the state. If the state legislature passes their law, you cannot exercise your executive in such a power to contravene your law. Everything must be in accordance with the law. The law must be in accordance with the Constitution. executive power must be in accordance with the law. That is the fundamental you will find principle. Therefore, under 257, it is executive power of the state vis-a-vis executive power of the union. State must use you will find in a slavish manner its executive power so that it does not impede or prejudice in exercising the executive power of the union. Now I will give you both cases, first under Article 256, second under Article 257. First case is J's Engineering Company Limited, J-A-Y. J Engineering Company Limited versus State of West Bengal. AIR, subject to correction 1968, Calcutta High Court. The Calcutta High Court consisting of, you will find 5 judges. The constitutional bench gave that particular decision. And all the judges unanimous conclusion. So what was the facts of the case? You remember who is the longest chief minister in India? Jyoti Basu. So Jyoti Basu was the chief minister, 25 years minimum. Like that there is one vice chancellor in India who was vice chancellor for 30 years. Anybody? Mudaliya, Dr. Mudaliya of Madras University, 30 years. Okay. Now in J's Engineering Company, that was the period of what do you call? What is that period? Gherao, picketing, then Gherao, don't permit to go outside, etc., etc. So that was the case. Now the state of West Bengal, through the cabinet of West Bengal, issued 2 circulars. The circular said, whenever there is a Gherao in any industrial establishment, police should not take action, even though a complaint is filed by the police. The matter must be referred to the Labour Minister. Labour Minister will apply his mind and tell what is required to be done. So that was a period of Gherao. Now, under the Trade Union Act, there are 2 sections. Section 17, Section 18. If a trade union leader does something in order to promote its objective, some immunity is given, civil immunity is given under Section 17 of the Trade Union Act, and criminal immunity is given, provided that objective is to promote trade union movement. So the argument in the cabinet resolution circular which was passed by the West Bengal categorically pointed out that in order to develop legitimate labor movements, we have issued this particular circular, and we should not be, no complaint should be taken cognizance of, because it is an exercise of legitimate labor movement. So don't interfere with it. So the J industry challenged the constitutional benefit. They said it's ultra-virus Article 256 of the Constitution. Because state is exercising its executive power. Circular is nothing but an executive order. And that executive order is against the Criminal Procedure Code, which is a parliamentary law. And Criminal Code says what should be done if a complaint is given. They have to acquaint with the facts of the case. They have to call the respective people. Their complaint must be taken in writing. Those who are making a complaint, you will find those persons must be ultimately heard. Everything is to be done. Now the effect and the impact of the circular is to violate Criminal Procedure Code, which is in the concurrent list. But Parliament is made, you will find, and therefore Article 256 of the Constitution is violated. The 5 judges of the Supreme Court, including taking. And therefore you will find it is violating of 256. You cannot do it. Nobody is trying to say that, look here, we want it is a bona fide decision. We are not looking into the decision making bona fide. But you must exercise executive power in accordance with the provisions of the Criminal Procedure Code. And the two circular issues were passed. Then there is another case, 257, 256, 257. The case is from Andhra Pradesh. I will stop it here, I can remember. Time is up, but just I wanted to. Katia Cooperative Building Society, Katia, CAA, versus State of Delhi, 1985, Andhra Pradesh, I take decision. Katia, CAA, Cooperative Building Society versus State of Delhi. Now, here a law was passed by Parliament, I think under Article 252. The law was what is known as Urban Land Ceilings Regulation Act. Section 20 of the Urban Land Ceiling Regulation Act categorically pointed out that state government is authorized to grant exemption in respect of vacant land. Operations of the Act, exemption can be given by the state government. And Section 36 empowered the central government to give direction to the state for the effective implementation of the provisions of the Act. Despite the direction issued under Section 36, what happened was state and government rejected all the applications for exemption. So the argument was exercising the executive power, center of state, state will have to vote, and therefore 256, 257 has not been complied with. You will find, and relief was ultimately given, you will find. So therefore, 256 and 257 come the way. Then what are the concerns? Very important. Now, that day, Governor of Kerala, Honorable Governor of Kerala, Muhammad Arif Khan, he said that the resolution cannot be passed by Kerala legislature. Since it is a matter of, you will find union based. And Arif Muhammad Khan is a just secular leader. And kindly remember, you may pass the resolution. The resolution is not a law to bring to a state. Resolution is a, what do you call, intention that a particular act will be done in a particular manner. It's not a law. But to say that law will not be implemented is wrong. Then another question comes. What is the question? Sometimes law is passed by the parliament, but it must be implemented by the state. They authorize Article 257, Clause 2. Parliamentary law will say, we are passing the law. Implementation must be done by the state. And this implementation is done by the state under 257 without the consent of the state. And if any expenditure is incurred by the state, central will pay for it. So therefore, because some of the provisions are implemented by the state, by virtue of the provision. I do not know Indian citizenship act also will be on that account. Therefore, Parliament should have thought over it. Instead of asking the state to implement it, they should have their own machinery to implement it. So that is one. So therefore, concerns, I will put it, the concern, I'm probably sorry, I have exceeded the time limit. Yes, what I have written is, see, the question is you cannot pick and choose the provisions of the Constitution. You cannot pick and choose. whether you are a citizen or you are a prominent political party, whether you are a ruling party or a representative, you cannot pick and choose. Suppose you say, I have a right to freedom of speech and expression, I will say this. What you must admit that other speech. You have got freedom to dissent. You have got freedom of assembly. Reason without harm. Subject to the reasonable criteria. Then, one chapter only shall not emphasize. There is a chapter on fundamental duty. Observe violence. Have a scientific temper. Have a spirit of inquiry. All these things are required. So you cannot say only fundamental. No. Fundamental duties are also important of all. A political party, any political party will support only those provisions which are. And our judge will, advocate will not say all this. Advocate will argue those provisions only. So this is therefore what is known as, you must look into the constitution, which is fundamental, holistic. This and that, but only article 14 and 55. There is a doctrine of classification. There are cases you will find in that. And then, how the court will react, don't predict. Don't predict. Even if there are cases earlier decided against you, court need not follow. There is one case. Kindly go through that case. Asad rickshaw pullers case. State of Punjab. Read that judgment. What was the judgment? There was a case where rickshaw pullers were there. The state of Punjab prohibited everything. Constitutionality of that prohibition came into existence. Then Justice V.R. Krishna, the activist judge, he called banks. He said, look here, these people are without rickshaws. Can you give a loan? Then the scheme was operated. Government of Punjab along with the bank gave loan ultimately. So therefore, don't think that it's ultra-virus of the constitution, it is intra-virus of the law. There will be certain other provisions which the court may make. So therefore, don't look into the judgment. Then another thing is, validity of the law is crucial. Don't put the, you will find, cart before the horse. Don't put the cart before. Wait for it. It will not, nothing will happen if you wait for the judgment. It may be in your favor, it may be according to my ignorance, we do not know. What the court may look into other area, can you change this particular case, this case, then we can review it. Then the court may be particular, you will find. And another important thing is, I would have wished, as a student of constitutional law, if NDA, before the presidential assent, referred this bill to the Supreme Court under Article 140. Because the English Special Courts Bill, special courts were created during emergency. The bill, before we assent to the president, was referred to the Supreme Court. Supreme Court suggested certain guidelines. You must appoint the judges only with the consent of the Chief Justice. So like that you could have, you will find, etc. And let us wait for the weighty, decisive judgment of the Supreme Court. Self-restraint, sobriety, and moderation must be our attitude and our approach. So that India that is not within the meaning of Article 1 can sustain. Thank you.